I did.
No, I'm not Peyton Ansley John Milton. I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
Thank you. And as to Mr. Milton, is there a competency concern, or is this
I am not represented by anybody besides myself in my sovereign capacity. Appreciate you.
Thank you, Your Honor. I did have an opportunity to speak to him. I read him the reports.
Who is him?
Don't interrupt. I'm letting
I read him.
Langley go. You just sit quietly.
Thank you.
I read him the report so that he will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented.
I can hear the music, but you can't. And it's thumping. I mean, it's like it's thumping in my ears. I forgot I've got it set up like this, which doesn't work very well for that. So I can just kill the music like that because you guys can't hear it anyway. But my apologies for no music on the intro. It sounded good. It sounded like this, and then it had like other things in it. But yeah, that was my fault. I'm running this through StreamYard, which is rare. I don't normally do a live stream through StreamYard like this. Our podcast does work on StreamYard, which is great, but we have other stuff to do tonight. Let's see. We have fun things. We have first of all, welcome to the Court of Public Opinion. I am the recovery addict. Thank you very much for joining me. Thank you for taking the blame for the no music. It was all my fault. The tractor was a lie. I still have it took forever. I used all the hot water showering, trying to get all the gasoline, the carburetor cleaner, and just get off insect repellent off me. I came home. Mrs. R.A. is like, "You stink." She said it a little nicer. She's like, "You smell bad," was what I think was her words. But I'm like, "Yes, I do. I smell like 3 different chemicals, none of which are this like yum type thing." So, but here we are. We're here. We have a late night bonus stream that we are bringing to you. The goodness, the wonderful true crime goodness, which we're bringing to you tonight, is courtesy of the Young Thug trial, which we have been following a couple of the, particularly the documents in this trial, because it's spicy. I'm so confused, but I love you, so it's okay, says Dr. Bullbutter. Is that working? Are you able to see? No. There you go. Now you can see chat. And Paula Mack, I think you were first in chat today. Congratulations. Thank you very much. We're going to send it to you with internet ownership. It looks like you ripped this victory from the clutches of Greeners, who I guess is sleeping tonight. So it's all good. It's all good though. I appreciate you being here first in chat. Help yourself to all the goodies that come with internet ownership, if there are any free snacks in the break room, right? All right, we have a read to do together. I don't know how long this is going to last, but let me give you the background on this story. Young Thug trial. It's a RICO case. It has 6 defendants who have multiple lawyers. They're all being charged at the same time, and it's taking forever. Jury selection took forever. It is taking forever. Throughout the course of this, the lawyers have been fighting very hard for their clients, and there have been some things that went on that the lawyers said, "Hey, this is not good. That's not right. This violates my client's rights," and it has built to a crescendo where there was one occurrence in the last week or so that really just set everybody off, and that was when they brought in a state's witness he was the star witness. Okay, he brought him in to testify against all his buddies. He took the stand and he pled the 5th, which you can't do with an immunity deal. That just voids the deal and you get arrested. So he got locked up for the weekend. They brought him in on Monday and said, "Look, we can hold you indefinitely, basically. I can hold you until all 26 other defendants are finished with their cases. It will be years, not just the 2 years that you thought you were going to just be okay, just sitting in court." And he says, "We can hold you that long." And he says, fine, I'll talk. I'll testify. But it'll be a lie. And they're like, if you lie, we're going to charge you with perjury. And he says, well, I'm going to get up there and I'm going to say that I committed the murder. And so it's crazy. The worst part about it, this whole meeting took place in an ex parte meeting with the judge and the prosecution, and the defense didn't know about it, and they should have, and the meeting shouldn't have happened in the first place in the way that it did. And when the defense found out about the meeting, they complained to the judge, and the judge, instead of saying, yeah, you're right, I should have told you about that, here's the minutes, what happened, he said, who told you about the meeting? You shouldn't know about this in the first place. If you don't tell me who told you, I'm going to throw you in jail. Ends up throwing a lawyer in jail over that. And this back and forth has just crescendoed into a explosion where multiple people have now gone to the judge and saying, Judge, you need to recuse yourself because this is not right. You're breaking the law. You're flaunting the law. And he said, no. 3 times he's refused to recuse himself. And 3 times he even refused to make the written decision that would then, cement it and everything. He's refused. And so they're taking it to a higher court. And it looks like this. The Supreme Court of the state of Georgia. Now, this particular document is, let's see if I can put it on my screen so I can see it, is from DeMonte Kendrick, who's the petitioner, versus the Chief Judge Glanville. He's not citing the case that Glanville's overseeing. It now is taking this straight to the Supreme Court of Georgia, the client versus the judge. And here we go. I have a little bit of water as well. So we've got, I love this, Weinstein, Hingerty, EJ Abt, Hingerty Law Firm, the Abt Law Firm, everyone's on here. Petitioners for DeMonte Kendrick. It has a table of contents. And let me say, I'm a little bit, I wish I had Kurt's knowledge when it comes to Supreme Court. I don't know in Georgia specifically what the laws are, but just in thinking this through, I think the defendants are in a bad spot because when the judge does something wrong, the normal remedy for that is an appeal. Well, here you have a judge who's doing something allegedly wrong and refusing to correct it. And the appeal doesn't come until the conviction. And then it could take years. And I'm not sure if the mechanism is in place. So we're going to look through here and see if there's a mechanism in place that will allow these defendants to get the relief they are seeking, which basically means we want the judge kicked off now. So we've cited a bunch of cases here. We're going to jump down through all this. I'm not going to read it all. Here we go. There we go. Comes now DeMonte Kendrick, who is the petitioner, by and through his undersigned counsels. It just means the defendant is doing this through his lawyers, and brings this emergency petition for writs of mandamus and a stay of proceedings showing as follows. Jurisdiction and explanation of emergency nature petition. One of the things that Supreme Courts always want to look at is to see if they're standing, if this is something they should even look at. That's the first thing. They're like, is this a case that A, you have standing in, and B, we should even be looking at, or is there another place this should have gone? And so the first thing they're addressing here is this issue. This emergency petition concerns allegations of serious breaches of the Georgia Code of Judicial Conduct that violate petitioner's state and federal constitutional rights. This petition relates to conduct of Chief Judge Glanville, hereafter called Glanville, and not to any rulings or orders of the judge. I think this is key. Not to any rulings or orders of the judge. It's just conduct of the judge. This court has jurisdiction over this matter under Georgia Constitution, Article VI, Section I, Paragraph IV, and OCGA 9624. In the case at bar, that means in this situation, that the case that's going on, original relief in the form of motions for refusal have been filed and denied 3 times by 3 respective movements. 3 different lawyers have asked for him to recuse himself, and he's denied. Likewise, Glanville has denied the movement's respective request for a certificate of immediate review 3 times. That's when you basically try to appeal the judge's decision immediately, I think involving another judge. And he's denied that as well. Glanville, as chief judge, has obstructed defense counsel's attempts to have a disinterested party review the numerous allegations contained in at least 4 affidavits, which allege judicial misconduct and unfair proceedings. These affidavits, if true, would constitute serious violations of the Code of Judicial Ethics. Citing a lack of evidentiary foundation caused by Glanville's own recalcitrance in refusing to provide a transcript of a secret ex parte proceeding, Glanville has hindered the defense counsel's ability to effectively pursue relief by claiming judicial privilege while denying certificates of immediate review. Assuming this court would not get the opportunity to review the decisions on the multiple motions to recuse unless or until the underlying case was concluded, they're saying that it would have to go through the appeal process to get there. Recalcitrance. Did I say extra C in there? Recalcitrance. Sorry about that. Glanville continues to hide behind a purported standard that his actions would be reviewed in hindsight for the abuse of discretion. So they're saying the judge is hiding by the fact that he says, if you don't like it, appeal after you're convicted. They're saying, no. We don't have to wait this long. This violation can be immediately addressed by the Supreme Court. And that's what this motion is trying to do. And this is the first motion that doesn't go to Glanville. He doesn't get to say no, denied. This goes to a different set of judges, namely Supreme Court judges, and they get to look at this. And it's a reach. It's a reach. Anyway, Glanville's obstruction of defendants' right to a fair and impartial trial has risen to a level that defense counsel now believes all attempts to obtain relief in the Superior Court of Fulton County will be ineffective. 3 motions for recusal have been filed and denied, and 2 writs of mandamus are already attached to the instant case, which were filed and pending for more than about 1 year. Therefore, any file of a writ of mandamus in Fulton County that would be heard by Chief Judge Glanville would result in frustration and lack of action. Glanville's court is where writs go to die. We're going to go back and read the footnotes here. A petition for writ of mandamus to order a return of seized property, in this case, relating to property seized during the arrest of Mr. Williams, was filed by the claimant, Raffaello and Company, on July 24th. It outlines the lack of action by Chief Judge Glanville over the course of time dating back to June 17th. The petition for the writ has yet to be heard by Chief Judge Glanville. And something else. That's just one of the examples. So this is his court is where writs go to die. As the petition for writ of mandamus would go to Glanville if filed in Fulton County Superior Court, petitioner has no option other than for the Georgia Supreme Court to exercise its discretion and consider defendants' claims. When you have a bad judge, what do you do? Where do you go? A secret ex parte proceeding was held on June 10th, 2024. In attendance were Glanville, sworn witness Kenneth Copeland, prosecutors Love and Hilton, investigators from the Fulton County DA's office, and members of the Fulton County Sheriff's Office. As a result of the proceeding on June 12th, petitioner requested that presiding Judge Glanville recuse himself from the petitioner's trial for, among other counts, count 2, murder. Despite preceding all requirements of Uniform Superior Court Rule 25, the motion for recusal was summarily denied without following the required procedure of USCR 25.3. This is basically accusing the judge of not following the law that he has to follow when a certain motion is made in his court. So the claimant has not agreed to any delay in the hearing of its petition. In the meantime, claimant is without over $1 million in their property loaned to Mr. Williams for his performances. An additional petition for writ of mandamus seeking similar relief on these facts was filed on October 24th and is yet to be heard by Chief Judge Glanville, despite efforts of claimant's counsel to have a hearing on the matter. They're just adding to this. These are the previous issues that we have. Glanville denied a request for a certificate of immediate review. A formal order denying the motion was entered on June 14th, 2 days after the motion for recusal was filed. As Chief Judge of the Fulton County Superior Court, Glanville holds a unique position within the county, which carries a significant amount of weight and power among his fellow county judges. Glanville has repeatedly refused to issue a certificate of immediate review that would permit the Georgia Court of Appeals to review his decision on the recusal motion. Therefore, invoking the original jurisdiction of this court to issue writs is petitioner's only recourse. This is important for the Supreme Court in Georgia to see that there is nowhere else we can go. There's no other court. There's no other judge. You are, help me, Obi-Wan Kenobi. You are our last hope, is what they're saying. If not considered by this honorable court, the still incarcerated defendant would be forced to wait for at least another year or more of trial before seeking appellate review. The appellate procedure in the case at bar will be extremely lengthy and cumbersome, with more than a year's worth of transcripts to review. It may take more than a year for the transcripts to be written. Okay, this could literally take years for relief if it has to go through with a sentence first. Emergency relief is requested because the witness that was coerced by Glanville is presently on the witness stand. Like, you guys, it's happening right now. Absent emergency relief from this court in some form, Glanville will control the scope and substance of undersigned counsel's cross-examination of Copeland. Anticipated areas of cross-examination include Brady material that counsel believes was disclosed at the proceeding but not provided to counsel as required by law, as well as coercive joint efforts of the bench and state. Given the conduct during the ex parte proceeding, at least an appearance of impropriety, if not actual impropriety, casts a pall over any ruling that Glanville may make during the counsel's cross-examination of Copeland. He's saying, we want to obviously the witness is on the stand. The state questions the witness. They get the evidence out of him they want. Then all the defense has the opportunity to question. And they say, with this judge on the bench, the way he's ruling, he won't let us ask, what did the judge tell you? What did the state tell you in that secret meeting? He won't let us do it. The relief that is sought is, as Glanville has found petitioner's motion for recusal to have been filed and presented in timely fashion, the Weinstein affidavit to be legally sufficient, and the affidavit containing facts that, if proven, would warrant recusal, petitioner requests this court grant a writ directing Glanville to adhere to Rule 25.3 and thus assign the motion for recusal for hearing before an unbiased judge. They're asking the court to tell him he has to do it. Petitioner further asks this court the proceedings in the trial, in this case, be stayed. So stop everything in the Young Thug trial, pending a resolution of the motion for recusal. Petitioner further asks this court for a writ ordering Glanville to produce immediately, and certainly no later than prior to the start of cross-examination of Copeland, an unredacted transcript to defendants of the secret ex parte meeting proceeding held on June 12, 2024. Petitioner also asks of this court that it enter any further writs or orders it deems appropriate given the actions of Glanville. Issues presented. Whether Glanville was correct in failing to allow the mandates of USCR 25.3 by refusing to refer the motion for recusal to an unbiased judge for hearing following argument on June 12th, particularly after making findings in the order of June 14th, that the motion was timely, the attached affidavit was legally sufficient, and that the affidavit contains assertions of fact to support the allegations of bias and impartiality. That's the issue. So the issue is whether Glanville was correct in failing to follow 25.3 when he found that the three requirements were met. Procedural history, statement of facts, backwards. In January 2023, nearly 18 months ago, a trial began in Fulton County Superior Court in state of DeMonte, Kendrick et al. Jury selection took more than 10 months, with trial before the selected jury beginning November 23rd. Following the secret ex parte proceeding on June 10th, the petitioner filed and presented a motion to recuse and accompanying affidavit with Douglas Weinstein to Glanville on June 12th. The motion to recuse was based on the impermissible secrecy of the ex parte proceeding and the violations of the Judicial Code of Conduct that occurred during that secret proceeding. The motion was summarily denied instanter with a formal order issued on June 14th. That means the judge basically said, I see your order, I'm denying it. It's like the rubber stamp, denied. Okay. And goes on, says the secret ex parte proceeding. A central figure, perhaps the central figure in the state's case against Kendrick and the other defendants is Mr. Kenneth Copeland. On Friday, June 7th, Copeland was sworn in. After being given a grant of immunity and being warned by Glanville that incarceration may be the result of refusing to testify, Copeland continued to plead the fifth. He wouldn't answer questions. Weinstein affidavit, see the example in the Weinstein affidavit. Copeland was held in contempt and ordered incarcerated by Glanville on that date. Glanville instructed Copeland and all parties that Copeland would be returned to court on Monday, June 10th at 8:30 a.m., where Copeland would announce whether he was prepared to testify. Unknown to any member of the defense, an ex parte proceeding was held in Glanville's chambers on June 10th. That's Monday. Among the attendees were Glanville, ADA Love, ADA Hilton, and investigators of the Fulton County District's Attorney's Office, deputies, sworn witness Copeland, and Copeland's attorney, Miss Kayla Bumpus. No member of defense counsel was present at the ex parte proceeding, despite Copeland's invocation of his Fifth Amendment rights being at a critical phase in the trial. Neither Glanville nor any member of the court staff, nor the Fulton County DA's office made any member of the defense counsel aware of the ex parte proceeding, either before, during, or after the proceeding. One or more members of the defense counsel were later made aware of the ex parte proceeding with the sworn witness Copeland, although not from Glanville nor from the DA's office. Oh, they're giving secrets of who didn't spill it. It's like, Judge, we can tell you it wasn't you that told us. And it wasn't the prosecutor either. Specifically, Weinstein learned that Brady material was disclosed in the ex parte proceeding and withheld from all defense counsel. Upon information and belief, the following events occurred at the ex parte proceeding with sworn witness Copeland in the chambers of Glanville. Upon information and belief, Copeland announced that he would invoke his Fifth Amendment right and not testify. Upon information and belief, Copeland stated that he would rather sit in jail for 2 years rather than testify. Upon information and belief, Glanville informed Copeland that Glanville could keep sworn witness Copeland incarcerated until additional defendants were tried, not just the 6 defendants currently on trial. Upon information and belief, ADA Love or Hilton informed Copeland that there were over a dozen defendants left to try. Upon information and belief, following the above coercive actions by Glanville, working in concert with one or more attorneys from the Fulton County DA's office, sworn witness Copeland stated at the ex parte proceeding that he would testify. Upon information and belief, Glanville also presented sworn witness Copeland with a printout of the perjury statute and the false statement statute of the state of Georgia during the ex parte proceeding. Upon information and belief, sworn witness Copeland stated to ADA Hilton that, if called to testify, he would simply lie on the stand. Important Brady material that has yet to be provided to Kendrick. Upon information and belief, in response to Copeland's statement that he would lie, ADA Hilton stated that she would not prosecute sworn witness Copeland if he were to lie on the stand. Important Brady material that has not been provided to Kendrick. Upon information and belief, sworn witness Copeland also stated to ADA Hilton that he would testify that he killed Donovan Thomas Jr. Important Brady material that has yet to be provided to Kendrick. Upon information and belief, in response to sworn witness Copeland stating to ADA Hilton that he would testify that he killed Donovan Thomas Jr., ADA Hilton told Copeland that she would prosecute him for perjury if he testified that he killed Thomas. Important Brady material that is yet to be provided to Kendrick. These troubling facts not only implicate Glanville in an impermissible effort to join forces with the state to coerce Copeland to testify, but also demonstrate an illicit effort to repress Brady material that should be provided to Kendrick. Attorney Kayla Bumpus, by and through her counsel, filed a motion to quash order to show cause and motion to recuse. So she was filing a motion to quash the order to show cause and motion to recuse, which is going to make her be in court in 5 days. On Friday, June 14th, which substantially supports the Weinstein affidavit. As a participant in the ex parte proceeding, Bumpus's firsthand account of the misconduct is credible. The facts Attorney Bumpus asserts are as follows. This is Bumpus's version of the meeting. On Monday, June 10th at approximately 8:30 a.m., Copeland and his lawyer, Attorney Kayla Bumpus, that's her, were escorted to the court chambers and conducted an ex parte proceeding regarding whether Copeland would testify. Those present for the substantive portion of this ex parte proceeding were Glanville, Copeland, Attorney Bumpus, lawyers Love and Hilton, members of the court security staff, and deputies, 2 investigators from the Fulton County District Attorney's Office, and the court reporter. In chambers, Glanville asked Copeland whether he was prepared to testify. Copeland announced that he planned to reassert his Fifth Amendment privilege, and a conversation among the parties ensued regarding Copeland's understanding of immunity, how Copeland thought he may testify if he did not invoke the Fifth, and certain facts of the case. Once Copeland learned that he could be held indefinitely by Glanville if he refused to testify, not just the 2 years as he initially believed, Copeland yielded. Copeland cautioned that his testimony would be a lie. Events in court about the time of the secret ex parte proceeding. On Monday, June 10th, all defense counsel were present in the Fulton County Courthouse at or around 8:30, admitted entrance to courtroom 1C, and seated within by 9 a.m. As shown in Exhibit A in the Weinstein affidavit, defense counsel waited and waited. Between 11 a.m. and 11:30 a.m., Glanville took the bench and announced that Copeland was prepared to testify. Sensing something amiss, Attorney Brian Steele, on behalf of all defense counsel, specifically asked Glanville about the reasons for the delay, providing Glanville an opportunity to reveal that an ex parte proceeding had occurred and the content of the proceeding. Failing to provide any substantive response, Glanville obstructed Steele's attempts to discover a reason for the delay. That afternoon, when Steele's understanding of the morning events was presented to the court by Steele, Glanville shifted focus away from the extraordinary allegations to the source of Steele's knowledge of the misconduct. When Steele refused to divulge this information, citing Rule 1.6 of the Rules of Professional Conduct, Glanville held Steele in criminal contempt and sentenced him to 20 days of incarceration. Then on Glanville's hearing on the motion to recuse and subsequent order, on June 12th, Kendrick filed and presented to the court his motion to recuse. During the 10-minute hearing on the motion, Glanville mischaracterized the motion as a complaint regarding his previous rulings. Glanville ignored the subject matter of the motion and affidavit, which was an accusation that the June 10th secret ex parte proceeding was a violation of at least Section 2.9 of the Georgia Code of Judicial Conduct, which assures every person, including defendants such as Kendrick, a fair hearing, and 2, in violation of Rule 2.11 in the revised Georgia Code of Judicial Conduct that says generally that judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. During the June 12th, 2024 hearing on the motion to recuse, Glanville refused to conduct the timely analysis required by USCR 25.3. Despite Weinstein bringing this to the court's attention, Glanville refused to make any findings and summarily denied the motion. Rubber stamped it, denied. Weinstein requested at that time a certificate of immediate review. That request was denied, foreclosing an opportunity to appeal Glanville's ruling. Glanville stated that an appellate court could look at his denial at the conclusion of the trial. While a transcript is not currently available, the video recordings of the entire proceedings can be found at this YouTube channel beginning at approximately 5:45. And then we've watched that. It's good stuff. On June 14th, 2024, Glanville issued an order on motion to recuse Chief Judge Glanville, attached as Exhibit B. The order formally denied the motion. In that order, the court did make findings, though not in the timely fashion required by USCR 25.3. The court found all 3 prongs of Rule 25.3 satisfied, and the analysis should have stopped there. But Glanville did not. Applying the wrong standard and reaching the wrong conclusion, Judge Glanville found that the court finds that a cursory review of the Weinstein affidavit submitted by plaintiffs in support of their motion contains assertions of fact to support the allegations of bias and impartiality. However, while these assertions were made to support defendants' allegations against Judge Glanville, there is a notable lack of evidence to support the assertions. This was the first of 3 motions to recuse denied by Glanville. And on June 18th, Judge Glanville denied 2 additional motions to recuse filed on behalf of Mr. Jeffrey Williams and Ms. Kayla Bumpus, respectively. Argument and citations to authority. Standards for granting writs of mandamus. Under Georgia Constitution, Article 6(1)(4), this court has those powers necessary in aid of its jurisdiction, including the power to issue process in the nature of mandamus and injunction. Well, lots of dots. 9620 allows parties to seek mandamus to compel a due performance of official duties where a defect of legal justice would ensure from a failure to perform or from improper performance that there is no other specific legal remedy for the legal rights. This is important. They have to get the Supreme Court to say, yes, we are your last hope. That's the only way they will hear this. If they see any other option, even one that is incredibly time-consuming, clunky, slow, whatever else, they're going to say, not us, not yet. They have to see through this that they are the only people that can intervene, and if they don't intervene, then irreparable harm is going to be done. To compel a removal of a judge, a petitioner for mandamus must show that a sufficient motion to recuse has been filed and that the motion has not been denied after assignment to a separate judge. It never got assigned to a separate judge. OCGA 9620, to preclude mandamus, the alternative legal remedy must be equally convenient, complete, and beneficial to the petitioner. Glanville has failed to follow the rules on recusal and has violated multiple rules of the Georgia Code of Judicial Conduct. When a trial judge is presented with a recusal motion and an accompanying affidavit, the judge must temporarily cease to act on the merits and determine immediately whether the motion is timely, whether the affidavit is legally sufficient, and whether the affidavit sets forth facts that, if proved, would warrant the assigned judge's recusal from the case. Glanville failed to follow USCR 25.3 during the hearing of the motion to recuse on June 12th. Glanville, following the filing and presentment of the motion to recuse on June 12th, failed to make the required determinations under the law. Glanville summarily denied the motion, relying on a mischaracterization of the Weinstein affidavit as a complaint about a ruling made by the court, instead of recognizing it as a list of incidents of judicial misconduct by Glanville. Glanville curiously clings to Baptist v. State as supporting his contention that Weinstein affidavit does not merit recusal, but there is no support in Baptist for this position. In fact, Baptist supports petitioner's position that Glanville's bias is of such a nature and intensity to prevent the defendant from obtaining a trial uninfluenced by the court's prejudgment. Glanville failed to follow USCR 25.3 in his order of June 14th. Glanville's order of June 14th contains a critical error of law. The law requires that when making a determination under USCR 25.3, the court must consider whether recusal would be warranted, assuming any of the facts alleged in the affidavit to be true. The judge is not allowed to pass on the truth of the allegations in the affidavit. He can't say, I don't know, the reasons are not good ones. I don't like those reasons. Instead, Glanville properly found that the Weinstein affidavit contains assertions of fact to support the allegations of bias and impartiality, which by law should have ended his inquiry. Glanville must then refer the recusal motion to a neutral judge to decide the merits of the motion pursuant to USCR 25.3. Glanville's factual review of the Weinstein affidavit is particularly astounding, given that Glanville has repeatedly refused to give defense counsel access to a transcript of the secret ex parte proceeding. It is apparent that Glanville has made every effort to keep the proceeding a secret and inaccessible to defense counsel, going so far as to hold Steele in criminal contempt for refusing to provide the name of our source and to issue an order of show cause to attorney Caleb Bumpus in an attempt to silence her. While Glanville's views appear to be evolving over time, Glanville has recently indicated that he may provide a redacted transcript of the proceeding prior to Copeland's cross-examination. However, at this point, Glanville is still indicating that any transcript provided will be redacted to remove privileged information. What could be privileged in a proceeding among the Chief Judge Glanville, the prosecution, sworn witness Copeland, and Copeland's attorney is a mystery. Glanville failed to follow USCR 25.3, Proper procedure requires referring a motion to recuse to an unbiased judge after the 3 prongs of Rule 25 have been met, which they were. Glanville has violated multiple rules of the Georgia Code of Judicial Conduct. Chief Judge Glanville's secret ex parte proceeding violated at least USCR 4.1 and Georgia Code of Judicial Conduct 2.9 and 2.11a. The facts alleged in the Weinstein affidavit must be assumed true when deciding whether recusal should be warranted. The details learned by Weinstein include the holding of an improper ex parte proceeding conducted with sworn witness Copeland. This violates Kendrick's rights to due process and a fair trial. The secret ex parte proceeding with a sworn witness Copeland was also a violation of at least 2.9 of the Georgia Judicial Conduct, which assures every person a fair hearing. Going back to read the notes here. USCR 4.1 generally prohibits ex parte communications except as authorized by law or by rule. Judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. Ex parte hearings are only authorized in the case of extraordinary matters, such as temporary restraining orders and temporary injunctions. In other judicial hearings, both parties should be notified of the hearing with an opportunity of attending and voicing any objection that may be properly registered. Georgia Code of Judicial Conduct 2.9, assuring fair hearings and averting ex parte communications, provides that judges shall accord to every person who has a legal interest in a proceeding, or that person's lawyer, the right to be heard according to the law. Judges shall not initiate, permit, or consider ex parte communications, or consider other communications made to them outside the presence of the parties or their lawyers concerning a pending proceeding or an impending matter, subject to the following exceptions. Where circumstances require, ex parte communications are authorized for scheduling administrative purposes, emergencies that do not deal with substantive matters or issues on the merits, provided that the judge reasonably believes that no party will gain procedural, substantive, or tactical advantage as a result of the ex parte communication, and that the judge makes provision promptly to notify all other parties of the substance of the ex parte communication and gives the parties an opportunity to respond. Judges may obtain the advice of a disinterested expert on the law applicable to a proceeding before the court if they give notice to the parties of the person consulted and the substance of the advice, and afford the parties a reasonable opportunity to respond. Getting notes for the boss. It's from 6-volt bus. How to repair 6-volt engine, or how to repair a lawnmower engine. Let's see. So we've got more. These are more. This is just, they just copied and pasted the rule. Okay, but which basically says these ex parte meetings are a no-go. They should not be happening. Ex parte communications are presumed to have been an error. Not only did Glanville fail to notify defense counsel about the ex parte proceeding as required by Rule 2.9, but Glanville made every effort to conceal the proceeding, as Attorney Lester Tate states in paragraph 14 of his affidavit in Exhibit C. In reviewing the video of the exchange between the judge, Glanville, and Attorney Steele, there was no disclosure of ex parte proceeding, which is now the subject of the show cause order. Indeed, quite the opposite takes place. Judge Glanville not only failed to disclose, he sought to keep others from disclosing and to punish those who might have already disclosed. Georgia Code of Judicial Conduct 2.11a says generally that judges shall disqualify themselves in any proceeding in which their impartiality might be reasonably questioned, followed by a non-exclusive list of specific situations in which recusal is required. The standard is an objective one. The facts must be considered from the perspective of a reasonable person, rather than from the perception of interested parties or their lawyer advocates, or from the perspective of the judge whose continued presence in the case is an issue. Furthermore, Chief Judge Glanville should not have coerced sworn witness Copeland to testify. A trial judge should not attempt to intimidate a witness to testify in behalf of the state, either in or out of the presence of the jury. As this court wrote, we need not decide whether such bias and impartiality actually existed, because judges are ethically bound to disqualify themselves whenever their impartiality might reasonably be questioned, including instances where the judge's behavior could indicate that he or she has a personal bias or prejudice concerning a party or a party's lawyer. Defendants were not provided notice of the hearing. Defense counsel should have been afforded an opportunity to attend any hearing where the sworn witness in a critical stage of the trial is being coerced to testify. The only logical conclusion for the secret nature of the proceeding was to give Glanville, in a conjunction with the state, unfettered ability to harass and intimidate the sworn witness into testifying. As the motion to recuse met all requirements of 25.1, 25.2, and 25.3, Chief Judge Glanville must assign the motion to recuse to another judge for consideration on the merits. A critical stage, by the way, is one which a defendant's rights may be lost, defense is waived, privileges claimed or waived, or in one in which the outcome of the case is substantially affected in some other way. How are we doing? You guys still with me? We're going strong. We're on page 29 of 83. Glanville's failing to follow USCR 25.3 violated at least Georgia Code of Conduct, Judicial Conduct 2.1. Rule 2.1 of the Georgia Judicial Code reads that judges shall respect and comply with the law and shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary. In the hearing of June 12th, Chief Judge Glanville failed to follow USCR 25.3 by failing to make the determinations required in a timely fashion. Petitioner did not repeat the details of Glanville's actions here. Glanville's failure to follow the requirements of Rule 25, both on June 12th and June 14th, were a violation of Rule 2.1 of the Georgia Code of Judicial Conduct. Conclusion: Glanville's actions offend public confidence in the independence, integrity, and impartiality of the judiciary. An appearance of impropriety and bias hangs over the present trial due to Glanville's failure to follow the law. As Attorney Tate writes in paragraph 15 of his affidavit in Exhibit C, here we have a judge who has failed to abide by a provision of the Code of Judicial Conduct designed to assure a fair hearing, who also has actively attempted to conceal the proceeding. In my opinion, to a reasonable degree of legal certainty, this conduct legitimately calls into question the judge's impartiality, and assuming it to be true, would require recusal. Again, I reached this conclusion based on Judge Glanville's actions, not any ruling that he has made in the course of this trial. The reason why they keep saying not on rulings that are made in the course of the trial is because rulings made on the course of the trial, if you disagree, the proper method is through appeal. And yes, at some point they may get to the Georgia Supreme Court, but it would first go through an appellate court, and you would only get to the appellate court once you've actually finished this case and there's been a verdict, and then you can appeal the verdict, and then you would talk about those issues on the rulings. That's one of the things you could include in your appeal. So they're saying it isn't that. We're not coming to you saying we have an issue about what he's done in the course of the trial. We're coming to you because he's breaking the law, which is different. So they're trying to, this is the only way that the Supreme Court will hear this. Petitioner requests this court direct Glanville to follow the law. Based on Glanville's own findings, Glanville should be directed by this court to assign the motion for recusal to an unbiased judge for hearing on the merits. Petitioner is further requesting a writ ordering Glanville to immediately produce an unredacted transcript to defendants of the secret ex parte meeting. I keep saying meeting, but it's proceeding. Petitioner further requests that proceedings in the trial be stayed pending resolution of the motion for recusal. Petitioner also requests this court enter any further writs of orders as it deems appropriate given Glanville's actions. This the 20th day of June, 2024. So this is a document that was filed today with the Supreme Court. This submission does not exceed the word count limit imposed by Rule 20. Respectfully submitted. By the way, they have a rule. You have to keep it short and to the point, and you can't exceed that. And he says it doesn't. That's one of the reasons the Supreme Court could throw it out. If you have too many words, it's like, sorry, you weren't brief enough. Now, in the appendix, we have read these together already, so I'm just going to breeze through them. We've got, first of all, the state of Georgia versus DeMonte Kendrick, motion to recuse the chief judge. This one went to the chief judge, and he summarily denied it. So we're going to skip this one because I believe we've read it already. Let's see, there's the law. More case law. Focus on the ex parte. Given the facts alleged assumed to be true, the judge should recuse himself. Should be assigned to another judge. There's the critical stage. Okay, there we go. So that's the Exhibit A. Exhibit B is Rule Nisi. Wherefore, the defendant, having filed a motion to recuse in the above captioned matter, is hereby ordered that the defendant's above motion shall be set down for a hearing on a certain date to wit of the blank day of 2024, blank o'clock in the courtroom. This is the blank, the fill in the blank. They literally wrote this for him and said, just fill in the blanks. This is all you need to do. Let's see. This is the state of Georgia certificate of service. This is to certify that they got this turned over to them. Now we have the Weinstein affidavit in support of the motion to recuse. This we also read, and this was presented to the judge previously, and the judge interpreted it as something that it was not, and then basically denied the motion. This is Exhibit 1. I like how it's labeled just Exhibit 1. They just wrote on it. Signed by Douglas Weinstein. And now Exhibit B, State of Georgia, order on motion to recuse Chief Judge Earl Glanville. Let's see. We're talking about Brian Steele held in criminal contempt. They lay out the same foundation. They go through these facts, and every document sort of breaks this down. They do talk about the fact that the Supreme Court of Georgia has issued a supersedis bond on the stay of Mr. Steele's contempt, meaning that Mr. Steele was supposed to spend 20 days in jail 2 days every weekend for the next 10 weeks. That supersedis bond means that it supersedes the judge's order, and they said you don't have to go it's pending our review. So we have already, they have taken action that has overruled Judge Glanville's actions. And that's a good sign for this motion, because they already see something and say, yeah, that's not really good. As a matter of fact, we're gonna put that ruling on hold while we look at it further and then decide. So that's a good start for them. Let's see, Rule 25. Talks about the timeliness of the motions, legal sufficiency, and the grounds. And these all qualified. The court actually, in their findings, in their response, basically proved that they accepted all 3 prongs of that test, but then failed to do the required step after those prongs are met. In conclusion, applying to the analysis required for motions to recuse as set forth in Rule 25 and further clarified by Georgia case law, the court finds the plaintiff's motion and affidavit have not met all 3 of the threshold conditions. Therefore, the motion is insufficient on its face. The court does not find it necessary to refer the motion to another judge. So this is the judge's ruling, striking it down, which was done, in my opinion, improperly. Affidavit of Lester Tate III. Let's see, I'm over the age of 18 years. I make this sworn testimony under oath. I'm suffering no legal disabilities. I'm competent to make this affidavit. Based on my personal knowledge of the facts here and set, I make this affidavit for all legal purposes. I'm the owner of Carter-based law firm Lester Tate Law Group. He's been a lawyer for 36 years. Served as the 48th president of the State Bar of Georgia. He holds a bachelor's degree from Georgia Institute of Technology and a law degree from University of South Carolina. Spent my entire professional career as a courtroom lawyer, having tried over 100 civil and criminal cases to verdict. I've been inducted into the American Board of Trial Advocates, ABOTA, one of the nation's most prestigious trial lawyer organizations, with the rank of advocate because of my extensive courtroom experience. I have previously served as the president of the Southeastern chapter of the American Board of Trial Advocates, CBOTA. Let's see. Lots of accolades and positions of trust. Licensed to practice law in Georgia, including the Supreme Court and in front of the Supreme Court, 18th Court of Appeals, all Georgia state courts. Have been admitted pro hoc vice in other jurisdictions, and have never been subject to any disciplinary action by any state bar concerning my provision of legal services in any court. So he's got a spotless record as a lawyer. Served as a member, vice chair, and chair of the Georgia Judicial Qualifications Commission. This is basically your equivalent to an expert witness, but it's a lawyer. Hey, Kurt. Let me. I'm on StreamYard, Kurt. So let me see if I can send you a link. 1 second. Let's do it down here. Okay, Kurt, it's just going to be in chat. Just open chat. But I'll only let you in. So anyone else joining won't get anywhere. There it is. It's in chat. Uncivil got the bat signal. Let's see. So he's got all these accolades. He's going on. He's developed a lot of expertise in all aspects of the Code of Judicial Conduct, including provisions that relate to ex parte communications by trial judges and standards for recusal. Further, my civil and criminal experience has provided me with extensive insight into issues which may arise at trial and how those might be handled. He's the professional you go to when you talk about this. He says, I haven't been to any of the trial, the Young Thug trial, but I've watched the videos online, including the whole bit with Brian Steele, with the ex parte witness, the prosecutors. This court exchange ultimately led to the contempt order of the court, which has been appealed to Georgia Supreme Court and stay pending resolution of the appeal. Lots of... I have specifically reviewed the order holding Steele in contempt of court attached hereto as Exhibit A and the show cause order issued by Judge Glanville directing parties to the ex parte meeting to show cause why they should not be held in contempt. That's going to be next week, and it's going to be fire if it happens. The opinions I express in this affidavit are based on the review of those video clips and a review of the attached exhibits. I express no opinion in this affidavit that is based on any ruling made by Judge Glanville. Instead, my opinions herein are based solely on his conduct in failing to comply with the Code of Judicial Conduct. So this is an expert testimony coming in to say, yeah, this guy, he's breaking the law. Supreme Court justices, he's breaking the law. Okay. We've got the show cause order referenced again, directs all parties to appear, where they're just going to sniff out who was a rat. And honestly, the lawyer, if it was the lawyer, they're going to have to divulge that it was them. Let's see. This part's interesting. The meeting, the show cause order, is now apparent that an ex parte meeting based on the show cause order. So he's working backwards here. He says, based on the show cause order, it's apparent that there was actually a meeting. Oh, I see you there, Kurt. Hang on just 1 second. Now this is going to be a little funky. Let me go over here. Hey, Kurt, I'm not sure if you can hear me or not.
I can, in fact.
Wonderful. Thanks for joining us. I see you. Let me in, Scott. I'm doing like, it looks funny the way I've got it set up.
Yeah. I'm not sure how you managed to pull that off, but okay.
It's a mix between hardware and software. So,
there. Okay, fine.
But the big thing here is that we have in the Young Thug case, which is just a circus, as you know, going on down there in Georgia with.
I've noticed.
It's getting worse, right? We're approaching the main act. I think if this show cause hearing, if we get that far before the Supreme Court steps in, it could be wild. But my concern is that the motion we're reading here right now, where they've taken it straight to the Supreme Court and saying we're not rulings in the case itself, we're appealing to you because we have nowhere else we can go. There's nowhere else we can go for relief because he is the chief judge. He's his own boss. There's nobody else. Then we have let me go full screen. Is that better? Now at least it looks normal. But they have to convince the Supreme Court to look at it.
Right.
And normally the Supreme Court would say, make sure you follow the right chain, right? If it were a regular a ruling in the trial, they would say go to an appellate court and work your way up that way. What are the odds they pick this up? Is this something that you think they're going to say, yeah, you're right, we are your last hope, and we need to step in here, or else the whole system gets broke?
So you're quite right that this is extraordinary. The last time we saw something like this was in the Delphi case with that judge, where that essentially was picked up by the Supreme Court of that state with respect to issues that could go to the issue of representation and whether or not the defendant was afforded the attorney of their choice and other relevant issues. So basically, at this point, this is where you are not strictly speaking asking for the court really to decide something on the case. You're essentially asking for their supervisory authority. So you're saying, hey, Supreme Court, by the nature of being Supreme Court, all the other lower courts are your children, and one of your children is misbehaving. So you're asking for relief that in some sense is external to the case. And as you might anticipate, that is abnormal. But it's possible in the federal system, and it is possible in many state systems. And there's usually a mechanism for this sort of public interest sort of direct appeal. But you're asking for something that is by its definition extraordinary. You're asking the Supreme Court to intervene because things have gone completely to heck. And typically you would think that wouldn't be prudent, but here I think the odds are better than not.
So what can the court do? I mean, other than sternly say, hey, follow the rules, or can they say, you know what, you're done?
They can do that.
Can they remove the judge? Can they remove his authority?
Yep.
Okay, so they do have a stick. They're not just able to speak loud. They're the big daddy court, so they can kind of do whatever they want to do. Sort of at the end of the day, it's like, yeah, no, you're not the judge anymore. Thanks for playing, or any sort of other relief that they want to, that they feel is required to bring this back to sanity. But I don't even know how that's hypothetically possible at this point anymore, because even if we got a new judge at this point, given what's going on, I don't know how you don't have clearly reversible error, which, then you're back to a new trial, presumably. Yeah.
So I mean, they could order a mistrial, which could hypothetically even be with prejudice, depending on if they thought the prosecution provoked it.
That would be crazy.
Yeah.
And would it only affect these defendants, these 6 in this?
It would only affect them insofar as the charges that are currently laid on the table that prejudice has been attached to. But that's not nothing. I mean, that's a pretty unlikely result that the Supreme Court is going to be like, how about this case goes away? But if they feel like the government has effed around and found out, especially if they feel like the state, for example, has somehow induced this ex parte hearing and other sort of things, then it gets into an issue, for lack of a better description, it gets into an issue of them trying to essentially provoke the mistrial. So if it's merely, them being incompetent, then no. But if the court believes that they're trying to provoke it, if they're doing it deliberately, then yeah, you can't do that. So it's unlikely, but it's a possible outcome.
I can't see, even with this going forward, even if the Supreme Court decides not to step in, which I think personally, I think they should step in, because it's getting absolutely crazy. I think you've got the public that is watching, and a lot of people are watching, losing faith in the judicial system because of this. And
Yeah.
so I think that as that chorus of complaints swells, even though the Supreme Court's not supposed to rule based on public opinion, they have reason to consider this and to take it up. And I think they have it's the proper, they've followed the proper procedure to get it to them. And so, yeah, but no matter what, even if the Supreme Court says, no, we'll pass on this one now, this is going to end in a mistrial.
I think that's incredibly likely. Or if it ends in a conviction, it ends in a reversal.
Yeah.
And because I just don't see, there's so many reversible issues at this point. It's hard to imagine how a conviction can stand at this point.
The length of the trial, as long as it's been, a reversal, an appeal would be a year before you could even file an appeal, right? Getting the transcript, going over everything, prepping everything.
As a practical matter, you're not necessarily wrong. Yeah. This at this point would be like one of the longest transcripts ever. I mean, just paying for the transcript will be 6 figures.
That is nuts.
It's a lot of pages, man.
Well, at least you can split the cost among 6 people. So I guess it makes it a little better. Because we've heard I think there's 30,000 was for what case was $30,000 for the transcripts? Was that Schroeder's?
Yeah.
I think that was the Schroeder case.
It took 8 months to seat the jury. So far into this case, we're 4 months into testimony. They've said that the trial will not end this year, which, December.
Yeah.
So there is no end in sight. So yes, that is a lot of pages. Start counting, baby. It's gonna get costly. Trees will die.
Cut down a whole forest to do it.
Yeah.
The motion, it's got everything. And these motions, there have been a lot of document drops in Young Thug for the past 2 weeks leading up to this. Because everything in this trial, because you have so many different lawyers, everyone's doing the whole Me Too. And so you get the same motion with basically mostly the same argument with just a couple changes in names from each person as they all sort of.
Of course, you want to preserve your issue for your client. Of course you do.
Piggyback.
If you have separate representation, then you need to file on behalf of each defendant. Of course you do.
And the judge has said throughout this trial that basically the Me Too rule applies, where you just have to say, if one person makes it, I'm just assume it's for everybody as well. But I'm not sure if that holds up on the appellate side if you don't raise any complaints. But
I don't know the rules closely enough to know for sure, but I don't mind their diligence on that issue.
Yeah.
But the underlying issue here with the ex parte hearing is problematic on a number of levels, not the least of which is it apparently involves a witness who is on the stand. And that presents a very real problem, because from the moment the witness is on the stand to the moment their testimony is done, regardless of what happens, they're on the stand. So lunch break, they're on the stand. They go home at night, they're on the stand, right? As a legal concept, right? Mm-hmm. That starts until it ends, and they're still on the stand
until they're released.
Sort of what happens until they're released, exactly, right? Yeah. And so their own lawyer can't talk to them about the case while they're on the stand. That's witness tampering. Because they're on the stand, they're giving live testimony, right? So their own lawyer can't talk to them except, in very narrow circumstances. It's witness tampering. It's obstruction of justice. And so you have a judge who is apparently bringing in a witness, ex parte, apparently not even notifying the parties after it happened, which is really bizarre, because even in limited circumstances where like an ex parte could happen, notification is given of the thing afterwards. Because it's like, I had to have an ex parte because reasons. Here are the reasons. But it's like the parties get to learn about it afterwards. And that didn't happen. So we have a secret ex parte. And it's like, even after the fact, it's secret. That doesn't sound right.
It was definitely secret. The judge
doesn't sound right. The judge
thought it was top secret. That's why he's so mad that people talked about it outside of chambers.
That doesn't make sense.
There was nothing that should have made it secret. You don't have attorney-client privilege with all the people that were involved in there. I mean, you've got.
See, like even if attorney-client privilege, you would still have by the way, we had the meeting. Here are the people that are present, and a vague discussion of a topic. Like we had the topic, whatever it would be, and you wouldn't necessarily go into detail about it, for reasons, but you still notify the other party it happened, even if it's after the fact. There's a due process problem, my friend.
I think I think when the transcript comes out, we're going to see one of two things. Either the full transcript of that ex parte meeting comes out and it is bad. I mean, like, it's really bad coercion, just blatant coercion.
Especially if the judge was, let's say, encouraging the witness in any way to change their testimony, because that's witness tampering.
Well, the other thing is that it comes out and it's so heavily redacted that there's just the appearance is so bad that you can't accept it on face value. You've got a 2-hour meeting and you come out with a page and a half of notes that say the witness decided to testify. No one's going to believe that. No one's going to say, we only redacted the parts that don't matter to you guys. But
that also sounds a lot like a due process problem.
Yeah.
So I think the odds of the Supreme Court giving its supervisory authority, where it just whacks the lower court around for the fun of it, has some chances. And it did happen in Delphi. And so, I think this is even more egregious. Different Supreme Court, but still. I think this is more egregious. So, you'd have to say that the odds are, not unrealistic.
What about with Miss Bumpus? She's the lawyer that quit or was fired. She was a stand-in lawyer, a fill-in lawyer for Mr. Copeland. She was only supposed to be there for the day. And she's like, look, I don't want any part of this. She actually she was in Law and Crimes chat later that day, apparently. A user account with her username, old account that's been around for a long time. Her image, and she was sort of saying, look, I didn't run away. There's stuff that's coming out that's bad. So that's very telling. We've got some screenshots of that. But what could happen to her? Because there is no law that she broke. There's no rule that she violated, but the judge is acting like she's nearly going to be in contempt. First of all, if she refuses to answer, I think he'll hold her in contempt. But
which I'm not sure that you can do that, because there's a Fifth Amendment issue, presumably, and you can't be forced to testify against yourself. So how does that work?
And she needs a lawyer to represent her, and it needs to be full hearing. And
and the other lawyer was asked, who told you? That's work product. So that's confidential, because I learned about it through my representation. So I don't have to answer that question. And it's just like, well, I'm going to start holding people into contempt. It's like, you can't force me to violate confidential information, even if the rules allow me to.
Yeah,
they don't require me to.
If he does violate it, then his own standing as a lawyer is in jeopardy.
Yeah, could be. I mean, you have to go look at the rules, and in some states, the attorney can violate privilege. They can. They don't have to, but they can, upon an order of the court. But some states allow for that, and some states don't. So you'd have to double check the specific rules. But it's like, even if there's no state that requires it, to the best of my knowledge. So be like, no has to be a valid answer.
Amber says the attorney Bumpus was on another attorney channel, is planning another appearance on the 25th on a different channel, the same day as the show cause hearing. I hope she does that during the show cause hearing. Like, she doesn't show for the show cause.
I don't even know who the show cause hearing is for, because the judge didn't specify. Apparently it's just anyone with knowledge in the case. Do I have to show up? I mean, I have some knowledge. Am I supposed to show up? I don't know.
Anybody, I don't
know.
Anyone who was there at the ex parte, in his show cause letter, he gave them more evidence that something bad had happened.
Yeah, which you kind of have to do, because you kind of have to, because you have to put them on notice about what they're essentially being charged with. It's a due process issue, so you have to tell them, oh, here's the bad thing you did. So you have to go spell out the details, so that's a valid show cause. So yeah, that's but it wouldn't be a problem if it wasn't supposed to be secret. So what are we talking about anyway?
Yeah, it's crazy. And then I don't know, as far as the trial goes, I have not been watching. Is Copeland still on the stand? Is he still?
I don't know who is or is not on the stand. And then you also have issues like suborning perjury, and because when you get a witness to lie and you know about it, that's called suborning perjury. That's illegal. Not only is it illegal because it's perjury, it's accessory to perjury. We call it suborning perjury, but same thing. So not only is it suborning perjury, but it's also a violation of a lawyer's ethical duties, because a lawyer has an ethical duty to show candor to the tribunal. Lawyers can't lie to the court.
Right.
We don't necessarily
if
have to
their
make things
witness
particularly.
lies-
We don't necessarily have to make things particularly clear, necessarily, but we can't out and out lie. And so when you suborn perjury, not only is it criminal, it's also an ethics violation. And so it's like, well, I guess your bar license is now in jeopardy, so that's super fun.
There's been some talk on both sides. The judge has mentioned it, the prosecutors have mentioned it, and the defense have mentioned their professional liabilities that they're breaching with all this. So everyone's threatening to report everyone else to the bar, which is sort of funny.
Well, I mean, if any
gonna be
case
some good
called
reading.
for it, this case sort of looks for review by somebody and
Yeah.
sort of what's going on. So I think whoever told the defense lawyers did the right thing, because I'm not sure that any order to the contrary would be valid, because due process, it's in the Constitution. I remember reading about it.
Yes.
So it's like, I'm not
My
sure an
money-
order. Don't tell the defense.
My money's on Miss
Like,
Bumpus. I think she was
yeah.
the one who talked, because she said in her motion, she was like, there's no reason for me not to talk. There's nothing secret. There's no order not to disclose. There was no expectation of secrecy that was mentioned at all in any of these proceedings. And there's not a standing rule that would indicate that this has to be secret. Yes, I can see with the court staff. I mean, the judge can expect that what happens in his chambers should be kept confidential. But among a meeting that size, there's no expectation outside that court.
How do you keep a secret between three people?
Have one of them be the judge.
That's not the answer to that joke,
Okay.
but we'll move on.
Yeah. Anyway, I think I scrolled through the rest of this. We've read all the other documents that are on this. They're just amendments and attachments to the rest. But I don't know how quick. I mean, this is an emergency motion, so the Supreme Court, usually Supreme Courts sort of work on their own schedule, but this is basically a request for them to step in immediately. We saw already that they did issue that supersedis bond for Attorney Steele that kept him out of jail on the weekends. So we know that they can act quickly if needed, but I think they're still reviewing that one as far as what's going to happen. But they at least put it on hold. So they might also do a similar type thing in order that this be put on hold while they look at it. And so the whole court just might pause going forward. Most Supreme Courts are thoughtful and methodical about rulings. They're not going to be reactionary like the rest. That's how you get on the Supreme Court. You're older, you're wiser. Okay, you're not going to just fall into the immediate rage and passion and rule that maybe a younger and more inexperienced judge could do. So
yeah, it's about thinking about the set of cases rather than the case in front of you, because it's like that old saying that bad facts make hard law. And this could be an example, right? This, if you assume this at face value, it's outrageous. And that obviously would cause you to want to do a potentially rash thing. But that's a really bad idea if you're the Supreme Court, because you have to think about the precedent and what you're saying about, the set of cases.
Yes.
So yeah, being more deliberative is in the nature of the job.
But it would not be, I mean, probably the first thing we'd see if they decide to do anything is basically put that hold on it. They put the bookmark in place, say, stop, we're going to stop and think about it. We'll hear arguments, or we'll hold a hearing or something, but it will be down the road and there'll be a big pause. Now, the flip side of that is you have 6 defendants currently in custody. And the Supreme Court's not going to say, hey, we'll take this up in 6 months.
No. If they decide to hear this, I would imagine it would be a fairly quick turnaround, all things considered. So,
and they do have a YouTube channel, right? So maybe we'll get to see this in the Supreme.
I mean, if you get the high court irritated enough, they can really, really bawl when they want to. I always remember the example like the Pentagon Papers case from the federal case, the newspaper that was going to publish the secret papers, and the government didn't want them to. That case went from being filed in district court to decision of the U.S. Supreme Court in something like 10 days flat. They can really bawl when they're really mad.
It's good stuff.
So But I'll let you get back to it unless you want my company for reviewing of whatever else
I think we're good, Kurt.
I
I appreciate that. We're going to wrap up. I'm way up past my bedtime, so I'm slurring words and everything's looking a little blurry to me
Cool.
right now. I'm just drinking water. I promise.
Can I pimp my channel?
Yes, please do.
Hey, I'm on civil law, and I've been covering the Karen Reed nightmare recently, so I've got some really cool content on that. So if you'd like to learn, I got some really cool 10-minute excerpts. I put out a 10-minute thing basically every day covering some witness from the state who said something that drives me absolutely insane. And I'm fairly convinced at this point it's caused me brain damage. So if you like that kind of thing, check it out on Uncivil Law. We're growing. We're at 139,000, hopefully 140,000 pretty soon, and maybe by 150,000 by the end of the trial. So check us out. Should be good.
That's awesome.
Uncivil Law out.
Kurt, always good to have you on. Thanks, my friend. We'll see you. All right. Appreciate his opinion. Wise legal mind there. It's got a wise legal mind with some great experience, especially when we're talking about things of this nature. So thank you. And thank you, 6 Volt Bus, for putting the channel there on the link. So you can click that if you want to jump over there and check out some of that. Kurt is not overselling these. They're excellent content. They are. It is late. We did. I know I've skipped through the last few pages, but honestly, it's like let me turn this one off so you can see me here. We've got just the same sort of documents. Where's my? Oh, that's over here. We've got the same attachments over and over, and it's the stuff we've read 2, sometimes 3 times before. The basic is that the judge broke the rules. He didn't follow the proper procedures, even though he found that the 3 prongs had been met. He didn't do them. He's acting. He's involved personally, and that's one of the reasons why he should be disqualified. He should recuse himself, but he won't. He's sort of standing as the gatekeeper to protect his position so that no other judge can rule on this by just summarily dismissing things when he shouldn't. And for all these reasons, this is why we're going to the Supreme Court with this motion that you step in and do something about it. And as Kurt said, they have some options if they decide to take this up, which I think they will. It's especially because they already took up the lesser issue, even though it was the straw that broke the camel's back, so to speak, of Attorney Steele getting held in contempt for this. So they already have their curiosity piqued regarding this whole ex parte meeting and the back and forth with the judge. And this now just puts all the pieces together in one big bow, which will allow them to possibly address the issue as a whole instead of just the issue with Attorney Steele, and then have to address something else separately. So maybe what we'll see is that the Supreme Court from Georgia takes this motion, this emergency motion, up and wraps Attorney Steele's into it or under it, so it falls under one umbrella and it's all gets fixed in one fell swoop. And great shall be the fall thereof. So wherefore, Attorney Bumpus moves this court to quash its order to show cause, wherein the alternative recuse itself. We read that before. The Attorney Bumpus wants that to happen. I haven't seen that yet. I don't think it's going to happen. I think that we're going to actually move forward and at least get to the show cause meeting on the 25th. I don't think the state or the Georgia Supreme Court is going to act before then. If they do, it'll just be a hold. But yeah, that's it. There's the order to show cause by the judge. It's just they put all the documents in one place so the Supreme Court can see everything in one big binder. 83 pages of it. Let me make sure there's nothing else that was new on this. That was the spicy one. That was fun to read. Certificate of service, and that's it. So that gets us to the end. All right. You're just now seeing this live, Taylor. There's some fun stuff. We read a little bit of new things. Basically, the same motions we've been seeing for the past couple of weeks in a week and a half or so in Young Thug. We're seeing those same arguments being raised, but instead of taking them to Judge Granville, who was just rejecting them and denying them every time they come up. They've now taken it to the higher court of the Supreme Court, which is the top court in the state of Georgia. And that court definitely has authority to act. And if they choose to do so, could fix the problem. So there will be fireworks either way. And I think this judge is not going to be happy. So if we still have court going on, you're going to see some raised tensions here, because he knows as of today that somebody went over his head and went straight to the Supreme Court, and he knows exactly who did it. So there could be some more fireworks in that court. So we're going to keep an eye on that as well. Anyway, tomorrow we are following Karen Reed. We will find out for the first time, because we're a day behind. We're going to find out if the judge allows those 3 witnesses in for the defense. But we're going to be back on the prosecution's case in chief as they finish up with some of their expert witnesses, some more expert than others. So good fun. Thanks to everybody who joined us tonight on the podcast. Thanks to all you helped me out as I tried to fix my tractor. That was a terrible stream. We're going to get a little bit of sleep tonight. I will, at least, and we're going to come back tomorrow morning by 8:30, 8:45-ish, somewhere in that range. I'm very tired. I'm sorry. And we'll be continuing with Karen Reed tomorrow. And it's Friday as well. We're also going to see if we can check in and see what happened with Corey Richins. I know there was supposed to be a hearing today. It will continue tomorrow in Utah. Might get some indication of when that trial is going to move forward. That's fingers crossed for that one. That's going to be a lot of fun if we get to go to see how that happens there in Utah. Other than that, let's see. No Pants Friday. Yeah. First in chat, as always, gets to win the internet. If you want to be that person, you have to beat Greeners, because he's got it figured out, and it's just refresh all morning long. I will try to pop the thumbnail up there on YouTube a little bit early for all of y'all. Tonight, when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again tomorrow morning, 8:45 for No Pants Friday. You guys have a great evening, and we will see you Friday morning. Be good to each other. See you.
Are we going to address subject matter jurisdiction?